So in the last video, we were looking at what law is and the attributes of good law. Now, we can have law and we can have good law, but if it isn't operationalized in certain ways, we can still have a less than ideal outcome. And this is where we hear this term, the rule of law. So what does the rule of law actually mean? Well, the rule of law is it's a term of art or a phrasing that talks about a way that law is implemented such that it creates a stable system for societal and economic life. So it's super important to business. Why don't we have a look? There's been a lot of notable thinkers who've thought about the rule of law. One of the classics is Professor Dicey from the 18th century. And there's some contesting of the detail of the definition. But in essence, we're looking for three key principles. Number one is the rules that we follow in society. The law is supreme. It's on top, and there should not be arbitrary uses of power. So there shouldn't be any person or any body that can overrule the law that's in place. The only way a law should be able to be overturned or overwritten is if it's according to the rules of law itself. So that means government or rulers are not the law. In fact, whatever they do must be done in accordance with the law. This leads to key concepts. For instance, it will come to ultra vires, right? We'll come to this when we get to the constitution element, but that's an example that we'll deal with in more detail. The second principle is that everyone's equal before the law. Private citizen, judge, PM, government official. Now, I think you've got to think through this because it doesn't actually mean what you might think it means. It doesn't mean that every individual gets treated exactly the same way all the time. And an example might help us look at that. Imagine there's an issue of running a red light. Let's deal with a traffic issue. Should you be allowed to run a red light? Well, generally, no. And no citizen is able to. I don't want to get into extenuating circumstances. Let's just think simply. But then, what about if you're a firefighter driving the firefighting truck? Well, you are, right? So some people would say, well, we're not treating people equally. That's not the way to think about it. The way to think about it is all firefighters, provided they're following the rules they have in place, all firefighters can run the red light. So if a citizen becomes a firefighter, they have this right. There's nothing stopping citizen Susie. If Susie becomes a firefighter, they get that right. So you might have to be qualified to get a right, but once you get it, you get it. It doesn't mean you're all treated the same all the time about everything. Hopefully that makes sense. Everyone is equal before the law. You don't get any special rights just because of law. That would be very different, for instance, if you were a king or queen. If you're a king or queen in the true meaning of that word, you get treated differently. The law doesn't apply to you the same way as it does to everyone else. So, just to recap, everything needs to be done in accordance with the law. The law is supreme. Second, everyone is equal before the law. You don't have special rights or exceptions based upon who you are. The third thing is that the rights of citizens are enforceable. Because without enforceability, people won't follow the law. So they're the three things. The law is supreme, everyone's equal before the law, the rights of citizens are enforceable. Once we have those three rules in place, then what we can say we have is the rule of law. And obviously, different societies have different levels of adoption of these three rules. So when people are talking about a certain country not having the rule of law, what they're really saying is that there may be some arbitrary use of power, which allows an elite to change the law whenever they want or not have the law apply to them. And if you have those hallmarks in your system, then you don't have the rule of law. That would mean, of course, that the law is actually very unstable because it's changeable. So it undermines this stable framework that we need for business and society. And I think that can be a very underappreciated fact. If you go back to Adam Smith and all the great thinkers, all the economists, right, they recognize that markets, for instance, only work if there are laws. A market won't work if your right to enforce the contract isn't enforceable. So all of the thinkers, even some of the more traditional laissez-faire economists like Milton Friedman, really believe in the rule of law. It's an important foundation that's shared across most of the economic thinkers. And as this quote says, it often operates as the software, the thing that's operating in the background that allows business to operate on top of that framework of law that's in place. So it's a critical component to business life, okay? The rule of law is important to a business that operates on that firm foundation. But that firm foundation doesn't need to be the same everywhere. And so it's important to understand the basis of our legal system and how it can differ from the legal systems in some other countries. Australia has what we call a common law system. We'll get into why we call it that. There are other systems in the world. Most of continental Europe actually has a civil law system that is derived from Roman law through Bonaparte and the French Empire to now most of them having a civil law system. There are other countries that have religious laws as the foundation, and of course there are customary laws in other countries that had less colonial influence. So we've got these basic four kinds. We probably could add that there are some communist systems, but they could be argued to be a subset of civil laws. We've got these basic four systems. So the hallmark of our system, the common law system, is that we have two sources of law. And that's what makes it quite different. The first source of law is legislation, or the law that's made by parliaments or politicians. So most countries have legislation and they'll have politicians of some form that make it. What discerns or differentiates common law is that we also have case law. And that's because our judges can actually make the law, okay? And that is very different to most other systems, particularly the civil law system, which is the other major system in the world. So we have legislation, which is a statute or an act of parliament. There's a subset of that we'll get to called delegated legislation. But in essence, parliament makes the law. In rare instances, it can allow other bodies to make some subsidiary laws around that. But we also have laws that are derived from historical courts. There were criminal courts, admiralty, commercial, family, right? There were different courts for different areas of law. And in a fascinating, well, I don't know whether it's fascinating for you, but in a plot twist, one of those courts dealt with common law. As a result of this, the entire use of the word common law can become very confusing. Common law can mean the system of law, like you see in the UK or in Australia or in the US, right? We're in common law systems. Or it can mean judge-made law. So it can mean the judge-made law within a common law system. Or it could mean, historically, the specific area of common law, a specific type of case law within the common law system. Now, while the system of law in any country tends to follow the historical precedents of who has held power in that country, what we also see is that most systems are in fact hybrid or mixed systems. So each country ends up with a unique blend of this, but there tends to be a predominance of a particular law. So, to summarise, Australia is a common law system. It's based on the British legal system, which has the binding effects of precedent or judge-made law. That means we have two core sources of law, legislation and case law, and the judiciary is more powerful and influential than in, say, for instance, civil law countries. Another highlight or differentiator of the system is that this means the courts operate differently. We operate on an adversarial system, which means the parties compete. The court is not trying to find truth. The court is weighing the best arguments put forward by the parties. It's a very different approach, and so we're in this adversarial system. So the court looks at the best arguments, whether between the state and the citizen or between two citizens. That means the parties are responsible for their own case. Now, look, there's lots of rules about how you run a case, things like rules of procedure and evidence, but the parties have to put their best case forward. It's not up to the judge to try and work out the best argument or the best ideas for each party. The judge is more of an impartial referee who observes and listens to what's going on and ensure that the rules are followed. And this is the same kind of approach you'll see in the UK, Canada, New Zealand, the US, etc. Anything that has this British legal heritage. Now we can contrast that with the other major system of law, the civil law system, where most of the law, the source of the law is legislation, whether it's a code, it could be called a code, a statute, or a constitution. Case law is not considered a source of law. They can be recorded and can be persuasive, but they're not a source of law. These systems tend to have derived from the Roman model, which was taken up by Napoleon and then spread across the globe. Under this system, courts aren't adversarial, they're inquisitorial. So they're inquiring into the truth. The judge is a government official rather than someone who comes from the ranks of lawyers. So they're more of an investigator. That's why you'll see in a lot of movies under different systems, they often kill the judge. And it's much more likely in a civil law system. Why? Because that official is more of an investigator. It doesn't make as much sense under a common law system, although it does get adopted in some plots, I understand that. But it makes much more sense under this civil law system. The judge is an active participant. They're investigating what's going on and they are trying to arrive at the truth. Now, in reality, some of the differences between civil and common law systems are decreasing. For instance, there's an increasing reliance on statute in the common law system such that the increasing codification in the common law system means that major difference is reducing. It's still there. We still have a lot of areas that are based upon judge-made law and judges still interpret and enforce the law with some different authority because of our system, but there's not this huge difference between judges making law versus codification. So while there's some decrease in difference, there are some major differences that remain. And the key one I'd like you to remember is this difference between an adversarial system and an inquisitorial system that in the way that they operate. That's super important. Say if you're an international student and you think courts run a certain way, you've probably been brought up with an approach about how they operate, right? And that can be very different, because I know from, say, the Australian situation, you can not understand how a court operates and why, say, judges would do certain things in other systems if you look at a civil law system. So it's really important to understand that distinction, especially if you're operating in an international context of business. And of course, classic examples are from continental Europe, France, Germany, Russia, and then where those countries started to have influence throughout the world, for instance, through Thailand, for example. So that's the key difference. One key thing that I'd like you to understand: there are different systems of government, and we need to contrast common law systems from civil law systems in particular. In the next video, we're actually going to have a look at the development of the common law system so that we can understand a little bit better how it actually operates.